Hello everybody and welcome. My name is Lisa Elliott and I am the London Regional Director here at the IEN. Just to let you know that this webinar is being recorded and we will be posting it later on the website as a resource for you. So this is part of a series of webinars that we are doing here at the IEN to support internationally educated nurses, and we are doing one a month. And you can find more details of that on our website. So today's topic is immigration and personal matters, and you will have an opportunity to ask questions at the end, so please use the Q&A facility that you have there. And on that point, I'm going to hand it over now to Anna and Sophia, who are going to take you through today's presentation.
So I'm going to be covering the health and care visa, and also what you need to do if you're on the health and care visa and looking to bring a partner and children to the UK, the procedure for changing employers, establishing the right to work, applying for settlement, and recourse to public funds. So the skilled worker visa replaced the Tier 2 general visa in 2020. The health and care visa is a subcategory of the main skilled worker visa category. And the eligibility criteria for the health and care visa is you need to be a qualified doctor, nurse, health professional, or adult social care professional. And you have been offered work in an eligible health or social care role. You also need to work for an employer that has been approved and licensed by the Home Office. So not all employers who wish to recruit healthcare staff can actually employ workers from overseas. They have to, that employer has to be licensed by the Home Office. And there's actually a list of current approved licensed employers available on the gov.uk website. Importantly, you need to have a certificate of sponsorship from your employer. You will not be able to complete a health and care visa application without this certificate of sponsorship. The certificate of sponsorship is a document that is issued. It can either be a physical paper document or sent to you digitally via email. That has to be issued to you by a licensed employer. So again, unless your employer is licensed, they cannot issue a certificate of sponsorship. There's also a minimum salary requirement in order to work under the health and care visa scheme. So if you're a nurse, your minimum salary must be £20,960. That's gross, so that's before tax is deducted, or £10.75 per hour. The only exception to this is nurses who initially enter the UK. Before they're entered onto the nursing and the NMC register, they will be classed as pre-registration nurses, and you will be allowed, whilst you're in the process of getting onto the nursing register, you will be allowed to earn less than that 20,960 figure. But the moment you are placed on the register, your employer has to pay you at that minimum 20,960 figure. If you're issued a certificate of sponsorship to work as a senior care worker, your minimum salary is 14,880 or £7.63 per hour. And care workers and home carers, it's 20,960 as well. So under the health and care visa, you are allowed, the main applicant is allowed to have family members with them, but that's only restricted to partners and children. And children can also include adopted children as well. If you're in a civil partnership or marriage, that's recognised in the UK. So although you may have married abroad, your marriage will be recognised in the UK. If you're not married, you have to show that you were living together in a relationship for at least 2 years prior to applying to enter the UK. So in terms of children, have to live with you unless they are eventually heading off to university or college once you're in the UK. They cannot be married or in a civil partnership or be financially supported by you. So this section is relevant for situations where the child has entered the UK with you, for instance, at the age of 16, and then once they reach the age of 18, when they become legally adults, they're still classed as children. So you would still, if you're applying to extend their visas, they're still classed as a child, although they are over the age of 18, but they must still be financially supported by you, and they can't have formed a separate relationship with somebody else and left home and got married. They will not be able to still be classed as your dependent. They would need to remain in the UK in a separate independent immigration category. So there's also a financial requirement if you're coming into the UK with partners and children. So you would need, the main applicant would need to show that they have £1,270 available to support themselves for their application. So this is a situation where you're applying initially to enter the UK. So that's for yourself. There's an additional 285 for a partner, £315 for one child, £200 for an additional child. Now, there is an exemption from this if your employer has indicated on the certificate of sponsorship that they will certify your maintenance. And most employers will do this. It's very rare. I probably seen one or two, a handful of incidents in situations where an employer hasn't certified maintenance. Often when that's happened, employers aren't aware that this is something that they can do, and they can actually just draft a letter that you can include with a visa application to say that they will actually certify your maintenance. So you won't actually have to provide bank statements to show this financial requirement. So again, you won't have to meet this financial requirement if you already are in the UK. So for example, and we'll get onto this in another slide, if you're changing employer and you have to submit another application, you won't have to meet that financial requirement if you've already been in the UK with a valid visa for at least 12 months. And as I've mentioned, your employer can cover your family's the financial requirement for the first month in the UK. So changing employer, this is really important. Once you're already in the UK working for one sponsor, you are allowed to change employers. So once you arrive and you're working for a particular sponsor, if after a period of time you choose to leave that employment, that's absolutely fine. You're not tied to an employer through the duration of your time in the UK. Now, the process of updating your visa is the same whether or not you have chosen to leave your employer, so you've resigned, whether you've been dismissed, or whether you've been made redundant. Perhaps the place that you've work for has closed. So it's the same process, regardless of how you leave. The next process in terms of updating your visa is the same. So you must find a new sponsor and you must submit an application to update your health and care visa with details of your new sponsor. So for example, for point number 3, if you've decided to change employer, you can continue working in your current job while your new application is being considered, or work out your notice period as long as you submit your application before your current visa expires. You cannot start working for your new employer until you've received a successful decision from the Home Office. So there have been instances where we've had members who've left an employer. they have then found a new job with a new sponsor, and that new sponsor has informed them, no, don't worry, I can still see there's 3 more years left on your biometric residence permit. You don't need to submit a new application to the Home Office. You can just start working, and that's not a problem. That does become a problem. We've had that in a few instances where that's happened. You will be deemed as working unlawfully if you change employer and have not submitted an actual application to update the Home Office. The process is, once you've left one sponsored employment, your old employer has to notify the Home Office that you've left. So the Home Office are aware that you've left employment with one sponsor, and they're basically waiting for you to submit an application to update your details. So it's really important that you actually follow the set procedure of getting a new certificate of sponsorship and submitting your application online. One of the things that you will be asked for when you, or before you start working for a new employer, is whether or not you have the right to work in the UK. Now, there are various ways that you can show this. For non-British and Irish citizens must provide an immigration, if you're not British or not an Irish citizen, you must provide an immigration status document, and that could be a letter that you had received stating that you have indefinite leave to remain. And that's usually in a situation if you're received settled status, EU settled status, you could print off your confirmation, go onto the online portal, print off that confirmation, or you provide a share code. Now, if you actually Google on the gov.uk website showing right to work share code, it will be one of the first websites that will come up. You will need either your passport, your current biometric residence permit, or ID card, whichever document the Home Office are aware of. Once you provide that information, whether it's your BRP reference or your passport, you'll then be asked to provide your date of birth. And once you have provided that information, it will confirm that you have a right to work. You will then click on another button and you'll get a page like this. And it's this particular share code that you will email your employer or next employer that confirms your right to work. And there's a similar system as well if you want to rent a property as well. That's a separate website with regards to showing your right to rent. All going well, you've resided in the UK for 5 years continuously with lawful residence. So by lawful residence, you've always worked for an employer with a valid certificate of sponsorship. You've been in receipt of the correct minimum salary, as I mentioned earlier. So, for example, if you're a nurse, your salary hasn't fallen below 20,960. You will be lawfully considered as lawfully resident in the UK. Once you have indefinite leave to remain, you will no longer be classed as a person subject to immigration control. So you will no longer need a certificate of sponsorship if you want to change work. Your salary can be whatever, it can be below the minimum threshold, and you will be eligible to apply for British citizenship. That's not mandatory, but you can apply for British citizenship if that's what you choose to do once you've held indefinite leave to remain status for 12 months. So recourse to public funds. Whilst you're in receipt of a health and care visa, your biometric residence permit clearly states that you have no recourse to public funds. There is no facility under this particular visa category to change that, unfortunately. You are, until such time you obtain indefinite leave to remain, you will be subject to this no recourse to public funds restriction. The Department for Work and Pensions provides a detailed list as to what is classed as public funds. And again, that is something you can go online, go to the Department for Work and Pensions and look for that list of public funds. It's a very long list. I haven't put it on here, but it's actually much easier to show you what funds you can actually, or what you can apply for. I've put this on here because, interestingly, when it comes to the list of public funds that you're not eligible for, childcare, this 30 hours free childcare is not actually included on that list of prohibited public funds. But as you can see, there is a restriction based on your immigration status. So if you have a child with you in the UK, you won't, to be eligible for 30 hours of free childcare, you must have a national insurance number and at least one of the following. So British or Irish citizenship, settled or pre-settled status, or if you have applied for that, you're waiting for a decision, or permission to access public funds as confirmed on your BRP. And if you have a partner, they must have a national insurance number too. So as you can see, this is not something that is available. 30 hours free childcare is not permitted. It is classed as a public fund. So you will not be eligible to claim 30 hours of free childcare until such time you have indefinite leave to remain. So what are not classed as public funds? So here's a list of items that aren't classed as public funds. So contribution-based job seekers allowance, guardian's allowance, incapacity benefit, contribution-based employment and support allowance, maternity allowance, retirement pension, statutory maternity pay, statutory sickness pay, widow's benefit and bereavement benefit. Now, if you want advice on any of those particular entitlements, we do have a welfare service, which is part of the member support service, and they can provide you with more information if you are interested in learning about what the entitlements are for these. I mean, commonly members that we speak to, maternity allowance, statutory sick pay, statutory maternity pay tend to be, an incapacity benefit tend to be the most common entitlements that people are asked questions about. That is my section over. I'm going to introduce you all, or hand you over to my colleague Anna Arguidas from the International Policy team. Thank you, Anna.
Thanks so much, Sophia, for that. So I'm Anna Arguidas. I'm the International Policy Manager at the RCN. And just wanted to come on here to talk to you briefly about some of the policy and influencing work that we're doing to represent internationally educated nurses. So we know that internationally educated nurses face a lot of immigration issues when they do arrive in the UK. This is just talking through some of the ways that we're trying to improve the immigration system through policy influencing. So our international policy team works with our research team and our public affairs team to influence government on issues that we know are impacting internationally educated nurses. Some of the key focus areas for us, I would say, is around promoting ethical recruitment and making sure that government and employers are actually recruiting people in ethical ways, that no one's subject to any kind of like unethical recruitment practices. We also focus a lot on immigration issues because we know that these are a huge concern for many of our members, and we also have a role in linking with nurses across the world through some of our international alliances. So just a bit of an overview of some of the key activity that we have taken recently to influence on immigration policy. So the RCN is continuously lobbying for improvements to immigration policies. So, for example, this includes our calls for the immigration health surcharge to be scrapped for health and care workers, which was successful. We also raised with government the difficulties that our internationally educated nurses face when they can't access public funds. We know that this is a huge challenge for many internationally educated nurses. We continue to make calls for policy changes so that internationally educated nurses might one day be able to access those critical public funds. Recently, we've been making a lot of calls on government to make indefinite leave to remain easier for internationally educated nurses to access. So we hear a lot of reports from members that often these costs are far too high for people to make applications. And I mean, an example of one of the ways that we influence government is by making written submissions to government. So, for example, we'll write to the Migration Advisory Committee on the behalf of the nursing profession. And the Migration Advisory Committee's role is to advise UK government on changes that should be made to the immigration system. So, for example, that committee's role will be to advise on which jobs are eligible for the health and care visa. So there was a recent change in the last couple of years where care workers can now be employed under the health and care visa. And that committee will also advise on roles that are eligible for the shortage of occupation list. Another key role of the policy function is to lobby government and MPs on bills that are in Parliament. So these bills are when government proposes new laws, they will have to be discussed by MPs in Parliament. And what we do is we'll work to speak to MPs to raise our concerns before those laws are passed. So most recently, we raised our concerns with politicians about proposals in the Illegal Migration Act, which made proposals around changes to the asylum system in the UK. And lastly, we also know that a lot of our members face many issues throughout the recruitment process, and a really big part of our focus recently has been ensuring that governments and employers are abiding to ethical recruitment principles. And something that we've recently done is worked with government to update guidance, particularly on charges that internationally educated nurses face in their contracts. As we know, oftentimes there'll be unfair charges applied to internationally recruited nurses. Yeah, I think that's it from me. So I'll pass back over to Lisa.
Lovely, thank you, Anna. And thank you also to Sophia. So please do use the Q&A box to put your questions to both Sophia and Anna. I'm just going to run through some of the benefits that you would have if you joined the Royal College of Nursing. So the first thing to highlight to you is the support you would get with your professional development. We are a professional body, we are the professional body for nurses, and you will get support with lifelong development and lifelong nursing learning with the RCN. You would have access to RCN Learn, which is a huge amount of learning resources on there for you. You would have access to Europe's biggest nursing library. Now, if you're old-fashioned and like to actually hold a book or hold a journal, you can actually go into the library, but you can also access our library online as well and have all of those resources online. The library staff will also give you a huge amount of support as well with your literature searches, etc. So there's a huge amount of support there. You would also have access to our forums and networks. We have 34 professional nursing forums over a range of specialities, and that gives you access to network with nurses who would share the same speciality and experience as yourself, as well as giving you the access and ability to be able to potentially influence future standards as well. When it comes to workplace support, we are the only nursing specific trade union in the UK, and we can provide you with specialist workplace support and workplace guidance, and that is what we are here for. We can also help with legal advice. We have the largest in-house legal team from any of the UK trade unions as well. We offer a vast amount when it comes to member support. We offer both emotional and practical support. So as you've heard already, we can provide you with immigration advice and welfare advice as well. We can also support you with career coaching, so we can support you with CV writing or preparing you for interviews or career planning. We can offer you access to counselling, telephone counselling, as well as peer support for members who may have disabilities. There's a really good handy guide to English expressions which we've just published, and that's fabulous. So if you've heard expressions from people saying things like spend a penny, those kind of things which may make no sense to you at all, there's a really good guide to actually what they mean. And lastly, we can also offer you careers advice as well. And we have an extensive resource and guidance there. So there is a QR code there. You can also, if you're interested in joining the RCN, go onto our website and you can go to rcn.org.uk to be able to join as well. So on that note, I'm going to end this here and go over to the Q&A. So with the current immigration rules, the visa restrictions are causing inequities in accessing professional university courses, resulting in career stagnation. Can I ask, is the RCN doing anything about this? Anna, did you want to pick that one up?
Yeah, so I just wanted to say thank you so much for raising this question, and we really are aware that the current visa system is very restrictive. It is something that the RCN is raising, but if you have any personal, if it's affecting you personally, please do reach out to us. So, I mean, one of the ways that we do raise it is that we'll speak to Department of Health and Social Care. We'll also raise this to government through consultations. So at the moment, we're just submitting a response on ways that the health and care visa actually isn't working for all internationally educated nurses, and how it just does need to be more flexible. But if you have any specific like questions relating to your own case, please do get in touch with us, as there may be something more personal that we can do for you.
Thank you, Anna. Are you hearing that this is something that a lot of IENs have experienced and a lot of internationally educated nurses are having to deal with?
Yeah, so I think we are really aware of issues around career progression for internationally educated nurses. This is a reoccurring topic. I know that in 2021, our members raised this as a Congress item, and we did discuss it at RCN Congress, and we have been and since it was raised, we have been doing more of a concerted effort across the RCN to try and make sure that the views of IENs are being fed back into us, and that we're actually taking action on this. But I do think some of the visa restrictions are contributing to that. You know, that feeling of maybe employers wrongly thinking that people are just temporary members of staff, and they're not. We need to be supporting them, for their careers in the UK.
If a nurse came into the UK months earlier than their family, do they all apply at the same time for indefinite leave to remain? So I think, Sophia, would that be one for you to pick up?
Yeah. No is the quick answer to that one. So for the partner, for the spouse, they have to be on their visa for 5 years. So if it means that at some point, just before their existing visa expires, so if they've been here for 3 years and their visa is about to expire, they must extend their visa to get to 5 years, and they're still classed as a health and care visa dependent. So even when they get to that point where they need to extend their visa, and the main applicant who arrived in the UK several months before them has now got their indefinite leave to remain, they still have to extend their visa as a health and care visa dependent. That's really important that they apply under that category and not as the spouse of somebody with indefinite leave to remain, which is a separate category that can cause all kinds of problems. If you're not sure, please, if you're in membership, get in contact with the immigration team before your spouse submits an application, because we've had a number of issues where the spouse has applied under the incorrect spouse category. They've received leave to remain in that category, but unfortunately, because it was in a brand new visa category, the clock restarts. So if they've already been here for 3 years, that is ignored, and they start from scratch under this other category that they've applied for. So it's taken them another 2 or 3 years before they can apply for ILR. So it's not, you can't all apply at the same time. For children, they can apply for indefinite, right, if they, there's ifs and buts here. If these children arrived in the UK after the main applicant, they can apply for indefinite leave to remain when their other parent who came with them, or maybe some time before or after, when they themselves get indefinite leave to remain. So if that's clear, so children can only apply for indefinite leave to remain with the other parent who came in shortly after. They can't apply for indefinite leave to remain at the same time as the main applicant. That's for situations where the children weren't born in the UK and they came here as dependents. If the main applicant gets here with their spouse and they have a child who's born here, they can apply for indefinite leave to remain at any point after their main applicant parent has achieved ILR. So the rules are slightly different for children born here compared to children who came here from abroad with their other parents. Hope that makes sense. Please get in contact with us because it's a bit tricky in terms of when dependent family members can apply for ILR. So as you can hear, it's not so straightforward. I mean, in a nutshell, ultimately they will be able to apply for indefinite leave to remain. When they're able to do so, it just depends on when they arrived and etc. Get in contact with us beforehand. You'll save yourself a lot of hassle in the long run.
Thank you, Sophia. And you're right, it does sound like a really tricky process to be able to navigate, especially without any advice. Can I ask, Sophia, within that, you talked about the other parent applying for indefinite leave to remain. Is there anything different if they are a single parent family?
Yes. And this is, and as Anna will testify, this is a long-running issue. I mean, for me, not since I've been at RCN, it's something that has been an issue throughout my career as an immigration lawyer. It's not impossible. So if a parent is separated from the other parent and wishes to bring their child to the UK as their visa dependent, there is an extra criteria that the immigration rules slot in for these situations. It's called the sole dependency rule. And what the parent in the UK who's already in the UK needs to show is that they provide their child is solely dependent on them. So one of the questions that the Home Office needs to satisfy themselves is that the other parent has virtually no role in the upbringing of that child. So a common scenario is the other parent has had no role in that upbringing. Sometimes they can't even locate the other parent. And in that instance, when you submit your application, you literally have to say that I have no idea where this parent is. My child is currently being raised by my relatives. It could be my mother, it could be a sister or brother, and the arrangement is purely temporary. It was just so that I could get established here, and then once that has occurred, I will then apply for my child to get here. But when you're submitting your application, there's a lot of information you have to provide. You literally have to show that you are that sole parent that's providing care. Now, if there's a situation where the other parent does have some role, that also provides an extra complication. I mean, initially, as a first piece of evidence you have to provide is a letter or an affidavit from that other parent giving permission for that child to travel to the UK. I mean, that's really important. Otherwise, the Home Office will reject that application, because they need to be satisfied that you're not taking a child out of a foreign jurisdiction without the knowledge of the other parent. So you need to have that in place. But you will also need to again show that although the other parent is still alive and is still present in that country of origin, that again there is no relationship between that parent and the other, and you will probably need to get the other parent to literally say that in the letter, that I have no role in the child's upbringing, however I do give permission for that child to reside with their other parent in the UK. Again, this is an issue that I would ask, if you are in that situation, to obtain advice on applying for your child if you are in that situation, because as I've said, their applications do get refused on that basis, because you haven't shown that you meet the sole dependency rule. If you're here under a health and care visa and your child has applied to join you as their dependent, and that application is refused, there is no right of appeal. You can ask for a review, but there is no right of appeal to an immigration tribunal. You only get a right of appeal if your child applies once you have indefinite leave to remain. But as I said earlier, you do have to wait 5 years, and obviously that's a long time to wait and be separated from a child, especially if they're a young child. That's a long time to wait, just so you could potentially get a right of appeal if your application is refused. So if you are here on a health and care visa, you are a lone parent, please get advice from us before your child makes that application, or if you have already made an application that's been refused, again, get advice from us in terms of putting in a review.
Lovely, thank you. Anna, was there anything you wanted to add before I went on to the next question?
No, just to say that, I mean, again, we know that it's just such an issue for members, particularly where they are a single parent. So again, it's something that we're raising with government really consistently. We would really like to see more flexibility and leniency in those immigration rules, because we know that far too often people are separated from their children for really prolonged periods of time. And we also have raised with government that we know a lot of people don't necessarily know about this before they arrive in the UK, and we want to make sure that everyone has all of the information they need before they come to the UK.
Sophia, this might be for you. What is pre-settled status, and when is the best time to apply for indefinite leave to remain?
Oh, pre-settled status that's part of the EU settled status scheme. So in order to get full EU settled status, you need to show 5 years residence in the UK. But if you haven't been in the UK for 5 years, the Home Office will grant you something called pre-settled status, and then you will be able to apply for full EU settled status once you get to that 5 years point.
Lovely, thank you. And when is the best time then to apply for indefinite leave to remain?
So for indefinite leave to remain, I mean, if you're here on a health and care visa, you have to have show that you've been resident in the UK for continuously for 5 years under that category. The 5 years starts from the date that you were issued the visa in the first place, so that will be the sticker in your passport that would have been placed there prior to entering the UK. But again, we do ask if you are in membership, or if you're not in membership, obtain membership to get advice with regard to applying for indefinite leave to remain, because we would want to just check with you that you do meet the 5 years lawful residence, because that's really, really important with regards to eligibility for indefinite leave to remain. But the earliest you can apply, once you've calculated, and again we can assist with how you calculate the 5 years continuous residence. Once you've calculated that, you can apply for quite early, actually. So if your 5 years is the 1st of October, if you can show that 5 years on the 1st of October, that period is reached, the earliest you can apply is 28 days before that. You can't apply for indefinitely to remain longer than 28 days before that 5-year point. But again, if you've got queries on how you calculate that 5 years, whether or not you meet that lawful continuous requirement, please get in contact with us first.
Lovely, thank you, Sophia. So our next question is around where to get support financially for the ILR application, asking if that's something the ICN would do, but also I think it would be good to understand where else people could go potentially. Now, I don't think that we would offer support for that application, but Sophia or Anna, do you have any, is there any way that we could signpost or any other things that members look to go to seek that kind of advice?
Yeah, unfortunately, I mean, the fees are due to also, the Home Office published that the fees are due to go up from the 4th of October. So they're quite expensive. If you want to apply for indefinite leave to remain, currently it's £2,404. It's due to go up to just over £2,800. Now you can imagine that would potentially bankrupt, I think, the organisation if we were to assist with fees. Now, I don't know. I mean, there are on the RCN Foundation website page, in addition to support that they can provide, they do provide details of other nursing bodies that support nurses. So, for example, the Edith Cavell Trust. You may want to get in contact with the other organisations that are on there. Now, again, if they are going to provide any support, I doubt very much that they would provide all of that fee, because it is a lot of money to apply for indefinite leave to remain. Some visa categories, not the health and care visa, unfortunately, but some other visa categories do allow for a fee waiver. So they will waive the fee of not only the immigration health surcharge, but also the application fee. Again, please get in contact with us if you are on another type of visa. For example, if you're on what's called a 10 years route to settlement and you are finding it difficult to pay for the application fee, please get in contact with us, because we can see whether or not we can assist you with applying for a waiver of that fee. But in terms of applying for indefinite leave to remain, there is no help, unfortunately, from the Royal College of Nursing or the foundation for the payment of that fee.
Someone has shared very personal experience, so I'll just read it out as they've written it in. I would like to ask about applying for indefinite leave to remain. In 2020, I went home for delivery. Unfortunately, I lost my baby. I stayed home for the rest of my maternity leave 1 year. This year is my 5th year working in the UK. I would like to ask if my stay outside of the UK for a year for maternity leave means my application for indefinite leave to remain is affected. Does that mean I can only apply next year, or am I now back to year 1? Sophia, I think that would be to you.
You wouldn't be back to year 1, but it would mean if you've been out of the UK for more than 180 days in any 12-month period. So they start from the date that you were first issued leave to enter the UK, and basically count 12 months from that period, then another 12 months, right up to the point that you're due to apply for indefinite leave to remain. So for any 12-month period, you're out of the UK for more than 180 days, there is a break in your continuous residence. So that would mean that that does push your ability to apply for indefinite leave to remain back somewhat. Doesn't mean you go back to zero. So long as when you return to the UK, you still had leave to remain, you wouldn't go back to zero. But we would have to help you with a calculation with regards to when you could actually, what the earliest date you could apply for indefinite leave to remain. Certainly get in contact with us. We could also assist with a letter of representation given the very compassionate circumstances around your absence from the UK as well. So do please get in contact with us if you need any support around applying for indefinite leave to remain.
Thank you, Sophia. The next question is, what is the least period of time for skilled nurses under Tier 2 allowed to enter and exit the UK?
So if you're already here on a health and care visa and you want to leave the UK, for example, you want to go back home just to visit family, so you can't be out of the UK for more than 180 days in any 12-month period, because as I've mentioned in the last question, that would affect your continuous residence in the UK. Now, in terms of absence from work, you're allowed to be absent from work unpaid, for example, for 4 weeks at a time. So if that 4 weeks means you're going to be away, that's fine. But any longer than that, there could be an issue. So for example, let's have an example. You would like to just take a break, go on a sabbatical for 3 months. There are some, you are allowed to be absent from work for sabbatical, but again, there's some immigration rules around that. If you need to do some humanitarian work abroad, you're allowed to be absent from work for that as well. Again, seek advice from us around being absent from work for those reasons. But in terms of being absent from the UK, you really need to look at that 180 days period. And to be honest with you, it's very unlikely that an employer would even allow you to be out of the UK for that long in any event, unless it was for, as I said, you're doing some humanitarian work, for example. So 180 days is the ultimate. That's ultimately you need to keep an eye on. It wouldn't mean that you would lose your immigration status as long as you return to the UK and you still had time left on your visa, but it could potentially affect your continuous residence in the UK. So I hope that answers it. But I think if you've got a sort of specific and you can provide us with a bit more information, again, give us a call and just we can go through it in a bit more detail if you are thinking about being absent from work and leaving the UK for any reason.
Lovely. Thank you, Sophia. Just going back to, I know we talked about if there was someone was a parent bringing over children. I just wondered with that, if you had caring responsibilities for a parent, would you be able to, would they be part of your application? Because you'd be able to bring over family members because of that?
Only if you have indefinite leave to remain. So if you are still here with what's called a limited leave to remain visa, such as a health and care visa, you wouldn't be eligible to submit an application. It's quite a difficult application to obtain or to be successful on. So not only does the family member who's here, or the adult child who's here, not only do they have to have indefinite leave to remain, they have to provide evidence as to the care that the parent needs isn't available in the country of origin. So you're in a good position here in the sense that the child here is going to be a nurse or any other healthcare professional. So you can. So I had an appeal a few years back where I was able to argue that, well, look, the care that the parent is going to get is going to be pretty good care. Not only they're coming to stay with a child that obviously is going to provide really good care for them, but this child is also a nurse and understands the medical needs of their parent. So I always recommend that if you want to apply for a parent to come to the UK as your sort of dependent relative, provide a care plan. What would the care plan look like? What would it look like once your parent gets here? So when you're at work, if you're doing regular sort of long shifts, who's going to be looking after your parent at that point? What plan have you got in place? And be quite specific about how that care will look. This is what I always advise people to do. And then state, well, this is what they would get here in their country of origin. They would not get this here, and then provide your reasons as to why they wouldn't get it. So is there nobody available? Or usually you'd have to say there's nobody available. You can't really argue, well, it's too expensive. The judges are not interested in that. Home Office not interested in that. So just state that there probably isn't anyone trusted, for example, who's available.
Can we leave the UK while in the process of indefinite leave to remain?
Quick answer to that. The immigration rules are really clear, and it's not just indefinite leave to remain, it's any visa applications. So if you're applying for an extension, the rules state that you cannot leave the common travel area. So what makes up the common travel area is obviously the UK and Ireland. So if you want to go the Republic of Ireland, so if you want to travel to Dublin or to the Channel Islands, so you want to go to Guernsey or somewhere for a nice break, that's fine because you're still within the common travel area. The moment you're out of that, your visa will be deemed, or your visa application will be deemed to have been withdrawn, and you will potentially, your application will be will end, and you won't get I think the most you get back, if your application was subject to the immigration health surcharge, you'll get that back, but you don't get the application fee back. So for ILR, which is currently 2,404 and is going to go up to over 2,800, you won't get that back.
Okay, thank you. Our next question, the 180 days away from the UK, does it apply to your spouse as well?
Yeah, it didn't always. This was something the government inserted in. I can't remember now. I think it was about January 2020 or 2021. For under what was back then a Tier 2 visa, it didn't apply to family members. So family members, spouse, children could actually be out of the UK for more than 180 days. Rules were amended. That applies to everybody now. So yeah. You do have to pay attention to that if you're on the health and care visa.
Thank you. And when you're due to get your indefinite leave to remain, can the Home Office refuse to grant it and ask the person to return home?
Unfortunately, there is no right for health and care visa applicants who are then applying for indefinite leave to remain. There is no right of appeal. Now, if when you submitted your application, you've been here for 5 years, and the main reason why these ILR applications are refused, it could be that you didn't meet the continuous residence, that you were out of the UK for more than 180 days in a 12-month period, or your sponsor has lost their license whilst your application has been under consideration. That was a common scenario a few years ago. We were getting a lot of those. Now, if you're in a situation where you still have some time left on your visa, so you submitted your application, your visa doesn't expire until October next year, but your 5 years, you were eligible now, you submitted your application, comes back as a no, you still have leave on you still have that time left on your visa. So your visa expires in 2024. You submitted your application for ILR this year. It's been refused. Unfortunately, you've lost £2,400. Unfortunately, you don't get that back. But the time that you have left on your visa is still there. That doesn't go. So you'd want to look at, well, what were the reasons for the refusal? And you would submit a new application. The problem happens if once you've submitted your application and your visa has since expired, then that becomes a situation, and we would have to speak to you and advise you based on your circumstances as to what potentially you could do at that point.
Is it possible to transfer from the NHS to private hospitals on the skilled work visa?
Yeah.
Sophia, you've got 60 seconds.
Okay, that's a nice easy one. You can go from the independent sector to the NHS and vice versa. The criteria is that they have to be licensed by the Home Office. I mean, most NHS trusts and health boards in Wales are licensed. In the independent sector, they would have to be licensed, basically. But you can. It happens all the time. People go from one sector to the other all the time. You're not restricted in that regard.
Lovely. Thank you so much. Can I thank both Sophia and Anna for today and for answering all your questions. There is a link in the chat. If you click on that link, you'll get a certificate of attendance. So thank you very much. As I say, this is a series event. Please check out on the RCN website for further webinars that we're doing. So thank you very much, and I hope you have a very good evening.